Okay. Good morning. We have counsel with us. Mr. Crawford, it is my understanding that you are here on behalf of the appellant.
That is
Therefore,
correct, Your Honor.
I would ask you, did you wish to reserve time for rebuttal?
Yes, Your Honor. I'd respectfully request 5 minutes for rebuttal.
Okay. It's noted, and I will do my best to interrupt you with the least amount of interruption as possible when we get to the
Thank you, Your Honor.
15-minute mark. With that, counsel, you may begin.
May it please the court. Good morning, Judge Casanueva, Judge Case, and Judge Vellante. My name is Andrew Crawford. I'm here on behalf of the appellant in this case. This case comes to this court after a final judgment for dissolution of marriage and amendment thereto. In this particular case, the main issue on appeal is alimony. This is a 27-year marriage at the time of filing, 28-year marriage at the time of filing. As the court well knows, there's a presumption in favor of permanent alimony. The final judgment in this case, the original final judgment reserved on alimony and equitable distribution. And then there was an amendment to the final judgment, which awarded nominal permanent alimony on Ms. Fabrizio's behalf. Now, in the original judgment and in the amendment to the final judgment, even without the benefit of a transcript, I would submit to this court requires reversal. There is no mention of the statutory factors or the mention of need or ability to pay in either of these judgments. On that fact alone, this court has held numerous times warrant reversal. Having said that, based on the transcript and based on the court's order, the court awarded Ms. Fabrizio $1 in permanent nominal alimony. The court made this finding of fact when the overwhelming evidence makes it clear that the husband makes over $120,000 a year. During the course of the proceedings, he bought a $365,000 house. And according to his financial affidavit and other documents, he pays $1,100 a month on food, $100 on his pet, $300 a month in entertainment, $75 a month in gifts, and $596 to his 401k.
Well, can I ask you a question, just so I understand? Is equitable distribution still up in the air?
Equitable distribution is not up in the air. Equitable distribution has been settled, and there has been no claim on appeal or at the lower court level or cross appeal as it relates to equitable distribution.
So what judgment are you appealing? The one that reserved jurisdiction on equitable distribution, or a different final judgment than the one with the compilation I have?
There's a final judgment, Your Honor. The amendment to the final judgment, which awarded nominal permanent alimony. The first judgment reserved. The second judgment awarded nominal permanent alimony.
All right. I don't think I have the attachment of the second, but I think I understand the argument better now. Thank you.
Yes, sir. Having said that, additionally, the husband's financial affidavit, which was filed in the second supplemental record, lists that he has a positive net assets of $955,578. Under these circumstances, the court awarded nominal permanent alimony without making any type of the required statutory considerations of the factors of Chapter 61, or without even mentioning need or ability to pay. The argument in this case, Your Honors, is that the court erred, number one, in not including the statutory factors or including need and ability to pay. Furthermore, the court erred when it awarded nominal alimony based on the wife's disability, which she testified to during the final hearing, as well as her inability to earn any income. The appellant's argument in opposition, or the appellee's argument in opposition to this, is that because she received $378,000 in equitable distribution and the parties were separated, that she's not entitled to alimony. This argument overlooks the fact that this court and multiple other courts throughout the state of Florida have specifically held in a long-term marriage when that the party entitled to the permanent alimony is not required to deplete all of their assets that they obtain through equitable distribution in order to maintain their standard of living during the marriage. Furthermore, Florida law does not recognize any type of legal separation or anything regarding that matter. There was a further testimony that during the separation, Mr. Fabrizio was additionally paying to his wife $2,000 to $1,500 a month in 2016. Therefore, he does have the ability to support her. And again, although he testified he did not have the ability to pay alimony, the court never made the specific finding as it was required to by statute. Furthermore, in addition to all the assets and claimed expenses he had, he paid for the expenses in full of his live-in girlfriend. She did not pay rent. She did not pay any of the utilities, although she mentioned she paid for some of the food. She didn't pay for a number of different factors. During the course of the proceedings and during COVID, he and his girlfriend, as admitted to by his testimony, went on vacation, and yet somehow he's claiming he cannot afford to pay his wife alimony. Based on these specific findings and based on the overwhelming testimony that was presented by the wife to the trial court, it was error to not only not make any findings as required by Chapter 61 of the Florida statutes, additionally not to go into any of the factors as it relates to alimony, but also to find that permanent nominal alimony was appropriate in this case. Additionally, the nominal permanent alimony, the final judgment only reserved 120 days for the wife to try and modify that. Now, first, there's two problems with this. First, it would be impossible for her to try to modify the final judgment within 120 days. Number two, she would have to show, as the statute requires.
Was the 120 days in there to amend the final judgment, or was that consistent with the judge saying, I haven't received the husband's compliance with equitable distribution? And it appears they passed in the mail. When the amended final judgment came out, I think it was filed then, but I think it was 120 days. So you could say, hey, here it is. We got it, Judge. But we need, I'm not sure that was specifically for that purpose.
Well, the final judgment, I have to go by the plain language of the final judgment, which said the court reserved jurisdiction for 120 days. So it would be.
That means it took all the issues, not just one. It didn't reserve jurisdiction limited to that. It said, I'm going to keep the case for 120 days. Is that how you read it also?
That's how I read it. But
okay,
regardless, it's impossible for her to modify and show a substantial change of circumstances within 120 days. Furthermore, the testimony was at trial that she was permanently disabled and unable to work and unable to find work during the course of the marriage. So what possible substantial change in circumstances, even if jurisdiction was extended, could she possibly show that would justify an upward modification of alimony? Your Honor, the case law is clear from this district, as well as all the other districts throughout the state of Florida, that what the trial court did in this particular case was error, not only on the face of the final judgment, but based on the testimony that was provided during the court. And I respectfully ask this court to reverse and remand not only for the lack of findings within the final judgment, but as it relates to the nominal permanent alimony that the court awarded in this case. And if there's no further questions, I'd respectfully reserve the balance of my time for rebuttal.
Well, the good news is I can reserve the 5 minutes because I think in our internal operating manual, we've indicated 5 is the maximum. I've been known to be wrong before, but that's my recollection. So I can reserve the 5.
Thank you, Your Honor.
Thank you, counsel. All right. Cleared off. Mr. Ristoff, you show being muted for me, so I would tell you that before you start, just in case you want us to hear you, right? I'm only kidding. I did that the other day on my always. I had my mic closed and everybody's like looking at me like, what are you doing, Judge? So, so I shared that with you.
Thank you.
I don't believe they didn't want to hear from me anyway, so they probably would have preferred that I left it, muted. Enough of that, sir. The floor is yours, counsel. You may begin.
This may it please the court. David Ristoff for the former husband, Stephen Fabrizio. Just as a quick background that was not discussed previously by opposing counsel. In this case, the former wife initially filed for dissolution of marriage back in 2010. That case was actually dismissed by the court due to a lack of prosecution. The case at issue today was filed on January 14, 2016, again by the former wife. At the time of the final judgment, the parties had been separated for nearly 10 years. That was also reflected in the amendment to the final judgment. The final judgment was entered by the court after three half days of trial that spanned over 2 years. from November 12, 2018 to September 2020. The case drug on for many years, not for any non-compliance as suggested in the initial brief of the former wife. They said it was just a very highly contentious case that
Can I just ask a question to get the math straightened out? Despite the dates of filing and dismissals and refiling, is there any dispute that this was still considered a long-term marriage based upon the date of most recent filing and the date of hearing, the final hearing?
No, Your Honor, except for the fact that they had been separated for 10 years, so it was not an intact marriage for the full 27 years. Still would have been 17 technically, I suppose, which is long-term. But during the early part of the marriage, the former wife was the breadwinner of the family, and throughout the course of litigation, both parties earned similar incomes. And it was not until 2018 that the former wife began to claim that she was injured and unable to make the same amount of money that she previously did in the past, but she was still employed at JCPenney's in the same position. Her permanent disability was only speculative, and there was actually no evidence other than her testimony that she's permanently disabled. In fact, the former wife worked from 2015 with the injury and did not even claim any losses in wages. During the trial,
Isn't there a financial affidavit that suggests she's back to working 4 hours a day in one of her financials?
That may be the case. However, at the
I
final,
forgot to look at the date of that, so I may have put in the wrong filing. So I'll withdraw the question, let you go on with your argument.
thank you. All right. And then, but at the very final day, which was 2 years later, she was no longer working. The former husband's accountant, Robert Szymanski, disputed the former wife's deficit that was testified to and stated that the former wife's calculations were incorrect and that both parties were spending more than what was testified to as to the wife's expert. Mr. Berg, the expert for the former wife, stated that the former husband would only have $48 available for alimony based on his financial affidavit. I believe that was the first day of trial. And then on the later date of trial, Mr. Berg changed his testimony to increase his ability to pay. The former husband, of course, testified that he did not have the ability to pay the alimony, and this was backed up by the former husband's affidavit, which showed that the former husband had a deficit of $923 per month. The former husband's expert also corroborated that the former husband did not have the ability to pay and that his expenses that were mentioned by opposing counsel were reasonable. It appears that the former wife's expert calculated the proposed alimony based on the gross income of the proposed worksheet. And then Tanner v. Tanner states that the parties it's error to base an alimony award upon a party's gross income rather than the net income. And it's interesting to note that the former wife initially only asked for $200 to $500 a month at trial, anticipating that she would be disabled in the future. But on the last day of trial, she came back with a much higher request of $2,000 to $2,500. And then in the memo, $3,096 per month. At the conclusion of the trial, the court ordered the parties to submit written closing arguments to the court, and the court had an opportunity to carefully review the detailed arguments of each party, including the relevant evidence provided in those memorandums. On November 10th,
Let me ask this question. As I looked at the transcript and read Judge Ramsberger's remarks, at the very end, he seems to compliment counsel and suggest to the parties that they need to talk to their lawyers about resolving this, which may lead to the reservation of 120 days. But there's nothing further in the record about that tells me what's going on, if anything at all. How should this court interpret that last message from the trial judge?
Well, Your Honor, throughout the
As
trial,
failure, that nothing happened?
it's not failure. No, throughout the transcript, you'll see that the court continually encourages the parties to settle the case. However, in the final judgment or the amendment to the final judgment, he does reserve jurisdiction for 120 days. However, this was resolved because we had later in April of 2021 entered a joint stipulation to extend jurisdiction. So that's been resolved. There's no more issue there. However, as you had mentioned, the judge has constantly asked the parties to settle the case because he feels that, I believe from the testimony and the transcript, that the issues were relatively straightforward and the parties should resolve it between themselves. On December 1st, 2020, a joint stipulation of substitution
Before
of
you
counsel.
go on, counsel, is the fact that there was an extension of jurisdiction in our appellate record that you all agreed to? If it's not, then you probably ought not to go there. And the reason I ask that is I don't remember, but it's a big record and I may have missed it. So there is that. So But I thank you for that piece of information, but we need to be cautious to be sure that what you know is what we know in our record.
I apologize, Your Honor. I don't know if it was ever later submitted.
That's all right. I just will caution, everybody, if it's not in our record, then you really don't want to go there. I don't want anybody to get blindsided.
The joint stipulation was entered, and the previous counsel for former husband did not file the equitable distribution proposal that was required by the court. He asked for an extension, but it was not until December 14th, 2021 that the court did enter the order substituting counsel. And then on December 21st, 2020, former husband did submit his equitable distribution proposal. As to the former wife's arguments, the court did not err in awarding nominal permanent alimony. Court did make some findings, which I think are acceptable in the amendment to the final judgment. It stated that he considered the factors of 6108. He considered the equitable distribution received by the parties and the financial situation of the parties, and considered the length of the separation of the parties. In the paragraph 13 of the original final judgment, court states the alimony usually cannot be determined in a case until equitable distribution is resolved, especially when an equalization payment is involved. Although this court has already done its alimony analysis relative to the various section 6108 factors in the case, until the
Up
court has
right there on that paragraph 13, that sentence, it says the trial court has already done its alimony analysis relative to the various 6108 factors. Where will this court find that?
the court only.
I went looking and I'm not sure I found it. And I want to be sure I didn't miss anything, or you guys know something that we don't know that it never got in the record. So I looked through what he said and I didn't see it orally, but I'm not going to say that I got through everything in the record. I got through most of it, but I didn't see that. So is it somewhere I should look?
It's only reflected in paragraph 6 of the amendment to the final judgment, where he again states that he considered the parties' financial circumstances and the factors under section 6108 of the Florida statutes. It's not, he doesn't go through it in detail.
How do we review that? I've got the same problem. That's why I asked that confusing question. How do we review something that's not a record? I mean, he may be right, but he's got to put something on the record so we can review it and give them a meaningful review on appeal.
And he may be right, but somebody needs to give us that part of the record where the trial judge did that.
The analysis is not contained in the transcript of the final judgment.
All right.
However, the court, through the testimony, did consider and specifically discuss the effect of equitable distribution on the financial needs of the parties, as we said in paragraph 6. Again, he states that he did reflect on it. At trial, the lower court heard the testimony of the wife and the wife's account and reviewed the documents submitted to the evidence, and considered the wife did receive $378,104 in equitable distribution. She also received $61,500 in disability settlement. The former wife admitted that she recently bought a 2018 Nissan Maxima. She spends $150 on clothes, $300 a month on grooming, and $200 on entertainment. And this is what she was spending after being terminated and is apparently disabled. In addition, the wife said that she applied for over 20 jobs and that she spends all that money for interviews. So the wife clearly believed that she was able to continue working. However, she wasn't working at the time. The husband, and the court harped on this, is that the husband did not provide any support to the wife for the 10 years of separation. Opposing counsel mentioned that he had paid a certain amount of money in 2016. However, the testimony was actually that he was paying half of the mortgage of the marital house up until 2016. He did not support the wife during the separation of 10 years. And this is a distinction from Lamont v. Lamont, cited by the former wife. And in that case, the husband did consistently pay support to the wife, who was essentially a homemaker for most of the marriage. In this case, the parties lived separate and provided for their own needs for 10 years. And then the wife worked and she supported herself for those 10 years. That's an important distinction. And even if the court did not specifically state the factors that it considered, the court could consider that it was harmless error and this could be found under the Cleat case and Esau v. Esau case. It would say no judgment shall be set aside or reversed for error as a matter of procedure unless it's apparent that the error complained of has resulted in miscarriage of justice. And that under section 59041 in a civil case, an error is reversible, that is harmful error, only where it is reasonably probable that a result more favorable to the appellant would have been reached if the error had not been committed. In this case, there's no miscarriage of justice, and even if the court had laid out all the factors, I believe that they would still reach the same result in nominal alimony. And it's not error even by the facts that nominal alimony was awarded, because alimony may be awarded when the court finds the requisite entitlement to alimony, but due to insufficient resources available at the time of the hearing, it cannot award sufficient alimony to meet the needs of the payee. The former husband provided testimony, and this expert provided testimony, that he had a deficit of $923 a month. The wife may have a need, but the former husband certainly did not have the ability to pay that need. This nominal award allows the former wife the ability for future modification.
Well, isn't that going to be somewhat debatable in the sense that as the trial court did not make any findings as to need, and then say the husband doesn't have the ability to pay that need, then now there's going to be a very difficult time to establish what the change is, as distinguished from the fact that the former husband may arguably have been excused from payment because of a lack of ability to pay. There's nothing in the,
Right,
if he finds that she has no need and this is nominal, then her need may change, and that's an easy factor. If, as you suggested in part of your argument, there's a need of there, let us say it's of hypothetically saying $10, and he can't afford to pay $10, her change of circumstances would have to then be her need is now 11 or above to show a change of circumstance.
Perhaps it seems as if at the time of the final judgment or at the final hearing, since the wife was unemployed, that the substantial change would be the former husband earning more money and being able to pay more money. He would have the more ability to pay. And there was testimony that the former husband was a silent partner in a business and he was continuing to work. So if he was making more money, he would have a greater ability to pay, and there could be a substantial change to increase.
By silent partner, that's the hot dog operation?
Yes.
Okay.
Yeah. As to the former husband paying for the in-home is his girlfriend, which is actually his fiance, there was actually no testimony that the former husband fully supported his girlfriend. And in fact, the testimony showed that the former husband paid for his living expenses, such as food and rent, and that she would pay for her own groceries. There was no extra money spent to support the girlfriend. In addition, the former wife also testified that she had went on vacation to Orlando. So there was no actual, the former wife is not destitute in this situation. By providing the former wife with nominal alimony, the court awarded an avenue for the former wife to obtain higher alimony if the former husband is able to earn more money in the future. The main issue that could be raised, Your Honor, is that there was no motion for rehearing filed either. Former wife complains that the judge is now retired, and that's true. However, there was no motion for rehearing. And as it's stated, and I know it's not a requirement in the second district, this could have been resolved if they had brought that up. There's nothing stopping the former wife from filing except for the failure to file. Essentially, we believe that the court did consider the factors. They spoke about the financial situation of the parties, consider the equitable distribution, the fact that they had been separated for 10 whole years. She self-supported for 10 years, and believe that the judgment should be affirmed.
Thank you, counsel. Mr. Crawford, you have your remaining 5 minutes, sir. And you are muted. No, not anymore. Thank you.
Thank you, Your Honor. Chapter 61 of the Florida Statute 61.08 makes a specific requirement on trial courts throughout the state, circuit courts, that when they're considering
Let me just
alimony-
interrupt you. I understand your argument, but what do you say to his point that if it's harmless error, it's harmless error? Is that a factor under that statute?
Not at all. Not at all. The trial court is required by statute and by the precedent of this court to make a specific finding before it awards alimony as it relates to need and ability to pay, as well as to go through the factors required under Chapter 60.
So here's my follow-up question. That your argument would be the same whether this was a long-term marriage with a presumption of permanent alimony or a short-term marriage or a moderate-term marriage. It doesn't change with the length of the marriage, because apparently that might be in dispute whether it's connected or unconnected for a period of time.
Correct. It would not matter. The law is clear that it has to say that, and it has to say that, Judge Vellante, because both you, yourself, and Judge Castellano have touched on, it's impossible for this court to review an alimony award unless
I'm
there's a
sorry to
statutory
interrupt you
factor.
again, because you're dealing with a pretty reputable trial judge. It's so
Correct.
odd to me that he would do a judgment that seems incomplete on its face. So was there a motion for rehearing in an attempt to correct this omission?
No. There's no requirement to file a motion for rehearing.
No, I understand that. No, I
Second,
totally
Yeah,
get
but
that.
it's a
I'm just
little
asking.
bit cheaper and quicker than doing an appeal, wouldn't you say? And the matter would be fresher in the judge's mind to say, hey, Judge, we need some, financial things. Otherwise, you're avoiding appellate review.
It is. It's my understanding, number one, that Judge Ramsberger, Peter Ramsberger, was retiring at that time. It's my understanding from trial counsel that he wasn't hearing any rehearings or anything else from the judicial assistant. I understand that's necessarily not in the record, but I have to respond to the question. A rehearing could not be filed. Furthermore, a successor judge, according to the law that I cited in the reply brief, could not go back and reconsider something that Judge Ramsberger had heard. Furthermore, again, there's no specific findings. It's an error in the final judgment. There is no, as appellee conceded, there is nothing in any transcript, in any court order, in any motion where the judge reviewed these factors, which is required under the statute. Furthermore, in terms of nominate permanent alimony, I don't think there's any dispute that it's a long-term marriage. The issue that counsel is arguing is that the husband does not have the ability to pay. And respectfully, we take issue with that when he is making $120,000 a year, spending $1,100 a month on food alone, and supporting.
You can't try the case here. So you can't try the case in front of us. That's something for the trial court. Your basic argument is it's defective on its face, according to Florida law.
Not only that, but nominate permanent alimony is only appropriate to be awarded when there's a finding of not an ability to pay. And there is, not only is there no such finding here, but it's clearly refuted by the record and the husband's own financial affidavit that he submitted.
Gotcha. Okay.
And again, with no factual findings, based on the record before us and appellee's concession that the wife is unemployed and is unable to find a job, I'd respectfully ask this court to reverse and remand. Judge, I understand.
I want to thank you. Don't worry about my question. It's fine. Thank you.
Yes, sir. Okay. Furthermore, this court has to make a finding that nominal alimony is appropriate under the circumstances and the evidence presented at the case. And I submit that the court made an error, not only on the face of the final judgment, but also upon the testimony that the husband testified to and his girlfriend testified to during the court, that she pays absolutely no living expenses. He lives in a $365,000 home. He makes $120,000 a year. And according to his own financial affidavit, he's got a positive net assets of $955,000. To claim that he cannot pay his wife $2,000 a month in alimony is refuted by the record itself. Furthermore, contrary to counsel's argument on page 194 of the supplemental record, the husband specifically said and testified that he paid his wife $200 to $1,500 per month in 2016. So he does have the ability to pay. The court erred when it made the finding that apparently implicit in the record that he did not have the ability to pay when it awarded nominal permanent alimony. Again, I'd respectfully ask the court to reverse and remand.
All right.
Thank you. Thank you both. Appreciate your presentation today, and please stay well. We hope sometime we'll get to see you all, as they say, live and in person.
Likewise, Your Honor.
Thank you very much.
Thank you.